The courtroom was the United States Senate. The defendant was the president. The verdict required 67 votes. No president has ever gotten that conviction. Here is why America's ultimate legal trial almost never ends in removal. The Constitution gives Congress a nuclear option. Article 2 Section 4 states that the president can be removed for treason, bribery, or other high crimes and misdemeanors. But here is what most people miss. Those words have no legal definition. The Founding Fathers deliberately left them vague. High crimes does not mean felonies. It means abuse of power. And who decides what qualifies? Politicians. Not judges. Not juries. Politicians voting on politicians. This creates the central paradox that has protected every president who faced removal. The very people voting have political motivations. They represent voters. They face elections. They belong to parties. And that changes everything about how this trial actually works. The impeachment process starts in the House of Representatives. Think of them as the prosecutor. Any member can introduce articles of impeachment. The Judiciary Committee investigates. They hold hearings. They gather evidence. Then they draft formal charges. These charges go to the full House for a vote. Only a simple majority is needed. 218 votes. That is it. If you think that sounds easy, you are right. The House has impeached 21 federal officials in American history. But here is where it gets complicated. Impeachment is not removal. Impeachment is just the indictment. The accusation. Getting charged with a crime is very different from being convicted. And the trial? That happens somewhere else entirely. Now let me show you what happens next. The Senate becomes the courtroom. 100 senators become the jury. And here is where it gets strange. When a president is on trial, the Chief Justice of the Supreme Court presides. But they have almost no power. They cannot dismiss charges. They cannot rule evidence inadmissible. They are essentially a referee who can be overruled by a simple majority vote. The senators themselves set the rules. They decide how long the trial lasts. They decide who testifies. They decide what evidence gets presented. Imagine a criminal trial where the jury could change the rules whenever they wanted. That is exactly what happens here. And that is why conviction becomes nearly impossible. But here is the number that changes everything. 2/3. The Constitution requires a 2/3 supermajority to convict and remove. 67 senators must vote guilty. In the entire history of American politics, partisan loyalty has never allowed that to happen for a president. Think about what this means. Even if a president commits obvious misconduct, their party only needs 34 senators to block removal. And those senators face political consequences. Their voters might support the president. Their donors might withdraw funding. Their primary opponents might attack them. The founders wanted removal to be difficult. They succeeded beyond their imagination. The political cost of voting to remove a president from your own party is often greater than the cost of ignoring the evidence. And this brings us to the case that proves everything I just said. Andrew Johnson. 1868. The first presidential impeachment trial in American history. Johnson was despised. He fought Congress at every turn. He violated the Tenure of Office Act by firing his Secretary of War. The House impeached him on 11 articles. The evidence was overwhelming. The trial lasted 2 months. And when the Senate voted? 35 guilty. 19 not guilty. Johnson survived by one single vote. Senator Edmund Ross of Kansas broke with his party. His political career ended that day. But here is what nobody expected. That one-vote margin would set the precedent for every impeachment that followed. Conviction was technically possible. But practically, almost unreachable. Richard Nixon understood this math perfectly. 1974. Watergate. The evidence was devastating. Secret recordings proved Nixon ordered the cover-up. The House Judiciary Committee approved 3 articles of impeachment. But Nixon counted the Senate votes. And he saw something terrifying. Republican senators were abandoning him. Barry Goldwater himself told Nixon he had maybe 15 Senate votes. Maybe. For the first time in history, conviction was actually possible. So Nixon did something no president had done before. He resigned. The system technically worked. But only because Nixon calculated his odds and quit. If he had fought? If he had forced a trial? Would 67 senators really have voted guilty? We will never know. But what Nixon proved was this. The threat of impeachment has more power than impeachment itself. So here is the truth about impeachment. It was designed to fail. Not because the founders made a mistake. But because they feared something worse than a corrupt president. They feared tyranny of the majority. They worried that Congress could remove presidents for political reasons alone. So they built in safeguards that made removal almost impossible. High crimes left undefined. Politicians judging politicians. A 2/3 threshold nearly unreachable in partisan America. The result is a process that holds presidents accountable in theory. But in practice? Impeachment is a political tool, not a legal one. Clinton was impeached. He stayed in office and his approval ratings went up. Trump was impeached twice. He stayed in office and ran for president again. The stain of impeachment is real. But removal? That requires something America has never truly had. 67 senators willing to put country over party. The Founding Fathers created a process that sounds powerful on paper. Remove the president. Protect democracy. Hold leaders accountable. But they also created a system where accountability requires something rare. Political courage. Senators must risk their careers.